Understand that you just wish to offer a short explanation. You may go ahead.
Thank you, Commissioners. Yesterday, another batch of documents were released on the TRC website. I was only interested to read what McAdam stated in Affidavit, but amongst all the documents, I saw a letter that Advocate Nche addressed to the Minister in January 2008. It is about a complaint by Reverend Shakani. I deemed it prudent not to refer to any of the matters dealt with in the letter, lest it be said that I amended my version after reading of this letter. The version I will give to the Commission is what I wrote months ago and was typed by my wife. Commissioners, little sleep and a gluttony of documents the last 3 days was taking a toll on me, on my health. It is a bit embarrassing for me to discuss my health on national TV and to ask for short adjournments all the time. I appreciate that it is always granted and that you understand my situation. Fortunately, I have my private physician next to me who will at all times, Jos Venter, who will monitor my compos mentis. With that being said, I can start in with the next topic.
Yes, just a correction. I don't think it matters much. Maybe the witness needs to say a glut of documents. Gluttony means avarice. But we understand what he's conveying, but gluttony means greed.
Yes, indeed. Indeed, Commissioner, thanks for pointing that out. So, certainly the witness is not greedy for more documents. I don't think any of us are. And in fact, we're now busy scrambling to try and find the documents that he has referred to.
Yeah, en ons weet hy's Afrikaans sprekend, né?
Except exactly. That I believe that there's a new word in the dictionary, the gluttony, there's over information, gluttony of information. That's where I picked it up. Again,
okay, thank you very much.
So I start then with the topic of Reverend Frank Shakani.
Yes, let's kick off, and just to advise the commissioners that we will probably only deal with 3 or 4 topics this morning, depending on how you feel. But let's kick off with what you want to say about your prosecution strategy in relation to the Frank Shakani matter.
Before I start in with the case itself, I think it's important to explain my prosecuting strategy relating to these atrocities committed by the security forces. Prior to the establishment of the PCL in 2003, I was a prosecutor in a number of human rights violation cases. Somewhere in 1997, I was instructed by the Attorney General, that was Dr. De Oliveira, to present myself at the Sambo building on Church Square. That was the first time I've been to that. I've already stated that I was not a member of the De Oliveira investigating team. Present at this meeting were a number of high-profile legal people. I didn't, mostly of the Goldstone Commission, but I also saw at that stage the Advocate Chaskelson, who later became the Chief Justice of South Africa, and there were also justice representatives. I believe there was a general of the Zimbabwe police force there too. I was probably introduced, but I can't recall them all. A number of police dockets were handed over to me with a brief to prosecute the persons mentioned in the dockets. The persons mentioned in the dockets were generals of the security force and senior politicians, but the main focus was on the notorious flock class unit. I perused the dockets and presented my report a week later. It was clear to me when I presented this report that people present there expected indictment and conspiracy trial. I, however, rejected the conspiracy trial, decided to prosecute Colonel Eugene de Kock as head of the flock class unit as the only accused.
Mr. Akin, if we can just pause there, I just want to follow up by way of clarification. You mentioned that this meeting was in or around 1997. Now, the Goldstone Commission wound up during the course, I believe, of 1994 or 1995, and you commenced your prosecution of Colonel Eugene de Kock in 1996. So is there a chance that that meeting was probably a little earlier than 1997?
It was before the prosecution of de Kock, the commencement of the prosecution. I had to draft it, so it must be a mistake I made in these notes. I don't know why I said 97 there.
Okay, that's a small matter. And just to confirm that the members of the Goldstone Commission, apart from Judge Goldstone himself, did it include Arthur Chaskelson and Judge Tyrion, as well as Nicholas Zitzman?
I know Judge Tyrion was not there because it's well known to me, I was from Pietermaritzburg. He was at the Pietermaritzburg office. He was a judge there.
Okay.
So I know he was not present.
But you recall that Arthur Chaskelson at that time was a member of the Goldstone Commission?
It must have been. He was there. That's the only person that I could really, he and Dr. De La Vera were the only people that I knew.
Okay. Thanks. You can proceed.
Now, as I stated, I rejected this conspiracy trial, decided to prosecute Eugene de Kock. My strategy was, perhaps I should explain, you get two counts, as the Commissioner knows, of conspiracies. You have the wagon wheel conspiracy where there's a person in the middle and he knows everybody, the spokes going out. And then you have a conspiracy calling, say, the chain links. And the person in a chain link only know the person on top of him and underneath him. So I work on the chain conspiracy method, where each part of the link is just linked to the person on top and will be able to incriminate that person. I was quite certain that after de Kock was convicted, he would implicate the perpetrators who gave him the orders. At that stage, I knew it was Krappies Engelbrecht, and the next person in the link was General Basie Smith, and the next general in the link will be General van der Merwe. That was my strategy, that the next accused will probably be then Krappies Engelbrecht. I had already at that stage drafted an indictment. Well, things did not work out the way I expected, because de Kock decided to join the stable of the TRC after he was convicted and he was out of my reach. Colonel de Kock, July winner, he was in their stable. When I decided later on to prosecute the perpetrators of Reverend Frank Shekani of attempted murder, I employed the same strategy. The Shekani matter was investigated during the trial of Dr. Wouter Basson, which I prosecuted. The Shekani matter, therefore, did not require any evidence investigations except the formal evidence in Madison in the USA. I discussed the matter with Mr. Nuka and later with Dr. Ramaiti and explained my strategy to them.
Can we just pause again? Just to be clear, if we can just go back to what you say about de Kock deciding to join the stable of the TRC and he was therefore out of your reach. When you say he joined the stable of the TRC, can you explain that in more detail, please? What did you mean joining the stable?
What happened is, after his conviction, we approached him. I was under the impression that he will implicate the people, Krappies, Engelbrecht, Basi, Smith, and I will take an affidavit from him because he was quite willing to implicate them. And I was under the impression he was going to approach us. But then I was told by somebody from the TRC, or I don't know how it came about, that he's off limits and that he's in a camp of the TRC. And as I said, from that moment on, he was out of my reach.
So did you mean he was at that point working with the investigators of the TRC rather than with the NPA?
Yes, that's correct. Yeah, that's...
Okay. And then you moved on to discuss your approach in relation to Dr. Wouter Basson, and you said except for formal evidence in Madison, USA, what formal evidence from Madison, USA are you referring to?
Of course, there were the clothes, there were the reports, the poison medical reports, the physicians who treated him because he went in about 3 times, and the FBI person who investigated the matter also had a number affidavit, because I had no evidence from the office.
Okay, thank you.
Now, I obtained knowledge from a source that the 3 perpetrators, those are the foot soldiers, name them, was General Christoffel Smith, Colonel Ger de Kock, and Johannes Mani van Staden, that they indicated that they were not going to take the fall for this poisoning. Somebody close to them told me that. So I knew that perhaps my strategy works out this time. At no stage did I, however, anticipate that Minister Vlok and Commissioner van der Merwe were going to admit to giving the orders and plead guilty. I said, to me, at least this time the strategy worked, except that it must be said that Vlok and van der Merwe only offered a plea after the negotiations between the state and the 3 foot soldiers failed. That must have been beginning of 2007 that Vlok and van der Merwe came on the scene. That is the time when the washing of feet started. Commissioner van der Merwe appeared about 5 times before the TRC Commission, but never said anything about the Shikani matter. Now, the attempted arrest of the Shikani accused.
Just before you start on that, you made a reference to the washing of feet. Was that in relation to the late Adrian Vlok's various attempts to, I suppose, reconcile with families and victims by washing their feet? Is that what you're referring to?
Exactly.
Thank you. Please proceed.
Approximately a week before the intended arrest of the accused foot soldiers, I contacted attorney Wagenaar and informed him that the three accused must present themselves at the magistrate's court or the police station, I'm not sure where it was, where they will be arrested and arraigned for trial in the Supreme Court of Pretoria, and that I will not oppose bail. During my discussions with Wagenaar, it was obvious that it caught him by surprise. In short, he told me again the whole story about it would be a futile exercise, but of course the politicians have already decided that there will be a special dispensation for the accused in TRC matters, and a bill to that effect will be presented to Parliament in the near future. I merely informed him to be at court with the three accused. I then made an appointment with Dr. Ramehiti to discuss this matter. I cannot recall all the matters we discussed, but it was in the main about the independence of the NPA and the powers of the Minister of Justice. A day or two before the arrest, Wagenaar phoned me again to inquire if I had been informed by the Justice Department about what was to happen with this case, the TRC case of Reverend Shikani. I said no, and once again informed him that he must ensure that the accused present themselves at the police station, otherwise they will be arrested at their place of abode. He informed me then, and the clerk was in contact with President Mbeki, and it was decided that all TRC prosecutions investigations must be put on hold pending the formulation of TRC guidelines policy, the policy guidelines. Now, the morning of the intended arrest, I received a phone call again from Wagenaar, who informed me that I would receive a call from the Minister of Justice, and that I would be advised that the case against the accused should be placed on hold. Shortly thereafter, indeed, I received a phone call from an official of Bangla's office who informed me that the decision had been taken by the minister and that the Shikani case should be placed on hold. I told the official that the minister does not have the power or authority to give me such an instruction, and that only the NDPP could give me such an instruction.
Mr. Ackerman, do you perchance recall the name of that official?
I've mentioned that it was that person said, hold on for Mr. De Lange. Immediately I thought it is the Deputy Minister, De Lange, that was going to talk to me. But when I spoke to this person, I don't know if I hanged on, I was not the Deputy Minister that spoke to me. So I don't know if there's another De Lange there, or that I was supposed to speak to the Deputy Minister, but the name De Lange came up. But it was not him. I know him and he knows me. He probably would have addressed me as Anton.
Okay, thank you.
Well, that's after I said I'm not taking any instructions from him. Approximately 15 minutes later, I received a call from Dr. Ramaiti requesting me to come to his office. Of course, I knew what it was all about. He told me that he received a call from Minister Mbandla informing him that he must not proceed with the arrest of the Shekani perpetrators and that the NPA must put on hold all investigations and prosecutions of TRC cases. I reminded him that we had discussed this scenario 2 or 3 days ago, and we both agreed that the minister did not have the power to give instructions to the NPA pertaining to prosecutions. We had an argument, a legal argument, I would say, I don't know, for approximately 15 minutes or 20 minutes, I'm not sure, because I was upset that Ramaiti, who previously agreed with me about the legal principles, had succumbed to this pressure by the minister. I've read the transcript of this Dr. Ramaiti's consultation with Mr. Semenya and agreed with the reasons he furnished to Mr. Semenya. And that is, he did not want to cause a conflict between the NPA and the Minister of Justice. He told me that the Justice Cluster's Directors General was going to formulate guidelines. That this cluster was not happy about my conduct in the prosecution of the TRC cases. Well, at that stage, I was not in the mood to have the same legal argument again with him and simply requested him to give me the instructions on what to do. The instruction was to stop the arrest, not to proceed with any TRC prosecutions. I stood up and walked out. Another heading I have here is meeting with Reverend Shekani on the 22nd of January 2007. Commissioners, it is relevant and important to explain what occurred before the meeting with Reverend Shekani. At some stage, I was informed by General Jacobs that Shekani was against the prosecution.
Mr. Ackerman, when you say General Jacobs, can you explain to the Commission who he is and what was his role at that time?
He was attached to the legal division of the police. He was also the representative, I think he was nominated by General Commissioner Celebi to sit on the so-called task team. The task team where that started its first sitting, I think, was here in October 26. And I knew him from a number of matters I had to deal with the police, but he was a legal man.
Thank you. Please proceed.
Now, as I said, it's important to explain what occurred before the meeting with Reverend Shekani on the 22nd. We had a number of meetings. As I said, I haven't got the dates here, but it must be middle of October, and we had about 3 meetings of the task team during that time. Now, at this meeting, virtually all the members, like a rehearsed choir, informed me that Reverend Shekani does not want a prosecution. There are the minutes of that meetings of the task team is available, and it's
yes. So the minutes that Mr. Ackerman is referring to, Commissioners, they're attached to the COI bundle, Mr. Ackerman's bundle that we provided separately from page 87 There are some of those minutes, and just before those minutes, there are also a number of emails between SAPS and a member of the NPA, Mthunzi Maga, and that's at page 82 to 83 of the same bundle, and it reflects this claim that the witness is talking about, that the Reverend Chikani did not want a prosecution.
At the bottom of the meeting of 6th of November 2006, there's a note. It is, however, worth mentioning that when Advocate Ackerman informed the meeting that the decision to prosecute has already been taken by the NDPP on the Reverend Chikani case, Josias indicated that the recommendations of the task team are necessary because the National Commissioner is of the view that Reverend Chikani is not interested in a prosecution of the matter. He suggested that contact has to be made to Reverend Chikani to ascertain his attitude.
Mr. Ackerman, before we read from documents, we need to make sure that we're all on the same page. And I need to refer the commissioners to the document you're reading from. Just can you remind us which document that is?
I don't know exactly where it is in the batch of documents, but it is the minutes. I'm going to refer to the minutes. I think there were 4 that I have quite extensively, because there's also another matter that emanates from these minutes. Yeah, I was told that this is page 70.
That's page 70 of the COI bundle.
Yes.
So that's titled Minutes of Task Team on TRC Cases meeting dated 6 November 2006.
That's correct.
Just hold on a moment. Commissioners, have you found that?
Yes, we are on
yes,
the same
thank you.
page with
Thank you. All right, we're all on the same page. Please proceed.
I will start. He suggested that contact has to be made with Reverend Chikani to ascertain his attitude. I think, I'm not sure that these dockets, these minutes were obtained from Commissioner Jacobs, whereas, of course, all the members received the minutes. And I think this one that I have was in his possession, and he probably gave it to the commission. Because there's in a hand and longhand stating the following. Ackerman also informed that NPA discussed the matter with Reverend Chikani, because at that stage I knew that the NDPP, Mr. Pakoli, also spoke to Mr. Chikani, to Reverend Chikani, and Reverend Chikani informed me that. I assume that that's why I stated it, and that's why it was written in longhand. Now, according to Advocate Ackerman, the complaint, Reverend, indicated that he leaves the matter in the hands of the NPA. It was then decided that the latter's attitude be ascertained, and the matter was therefore closed, pending a feedback on his attitude. If I can carry on, there's another minute of the task team. It's on page 87. And it says minutes of task team meeting 29/1/2007. You have that copy?
Yes, page 87, minutes of task team meeting dated 29 January 2007. You can proceed.
May I read from that document?
Please go ahead.
This third paragraph, starting with, this is now the meetings. Advocate Ackerman requested members for their input with a view to finalize the draft report to be submitted to the National Director. Commissioner Jacobs indicated he was made to understand that Reverend Shikani was not interested in the prosecution of the accused in this case. Therefore, he needs to be consulted and the matter needs to be discussed with their principals before making a recommendation. Advocate Ackerman reminded the meeting that the National Director has made his decision on this matter. Yvonne Mabule, she's a representative, I don't have here, but I think of NIA, stated, concurred with Commissioner Jacobs on the Reverend Shikani matter. Negiwe said he had no objection to the National Director's decision on this matter. You can see that the Shikani matter played a central role all the meetings of the task team. They were very concerned about that matter.
Yes.
Now,
just to be clear about some of the role players, so you mentioned that Yvonne Mabule was one of the National Intelligence Agency representatives, and the Mr. Ngidi, Nhlanhla Ngidi, was he from the DSO?
Yes.
Scorpions.
There is a list somewhere where it says where they all from. I'm not sure. I know where Jacobs was. I know where Mtunzi Maga was. 81. Is it? On page 81, we find the list of the positions these representatives hold. I haven't got it in front of me, but I don't remember.
Okay, thanks. That is helpful. And in fact, Mr. Ngidi was from the DSO. You can proceed.
Now, let's see. This is 82. There's a trial of emails between Commissioner Jacobs and Mtunzi Maga.
That's at page 82 of your bundle. You can proceed.
And this was sent on the 6th of December 2006, where from Commissioner Jacobs to Mtunzi Maga. Dear Mtunzi, I've said I'm waiting to brief the National Commissioner on the draft report. I will revert to you once I've spoken to him. Provisionally, I wish to indicate that from SAP's side, we are still not happy how the Shikani matter is reflected. There was definite decision that the Reverend Shikani must be consulted. Again, that the witness, that his wishes need to be reflected, that the issue be reported to our principals, and that they must make a recommendation to the NDPP on the matter. And that is, again, it appears that the only concern this task team had was the permission of Shikani to proceed, not prosecute him. Well, say that Mr. Piccoli informed me that Shikani, and that's it, is not in favor of a prosecution, and I gave him my views on the matter, and I refer the Commission to the following documents. These are two documents on page 88 and 89. Let me start with the 89, page 89. It's a letter addressed to Mr. Pekoli from the National Commissioner, where he says, it was brought to my attention that State vs. Otto, that's one of the perpetrators in Shikani matter, a decision to prosecute was taken without consultation with the respective departments. I have insisted that the complainant be consulted in terms of the guidelines on the basis that the Directors Generals will have an opportunity to provide input before a decision on prosecution is taken. That decision has already been taken.
If we can just pause for a moment, there's and this is for the technical experts. It says the battery on this computer is running low. Oh, and that's because the power wasn't switched on? Okay, we're back on board. Apologies, Mr. Ackerman.
Yes, page 89, that's the letter where they talk, again, it was the central problem they had was the Shikani matter. The Commissioner says and also the following. Although I do not insist on a meeting of the Directors General after each meeting of our officials, I deem it necessary that the substantive reports and the recommendations of the officials should be discussed by the Directors General before a decision is made. I am of the opinion that the Directors General should meet as soon as possible to provide guidance on the procedure to be followed by the officials in the task team. I also of the opinion that the Shikani matter should be discussed both in terms of the procedures followed and the way forward. I have requested the NPA to request a meeting as soon as possible and trust that you will be in agreement with that request.
Thank you, Mr. Ackerman.
And then there's a letter.
Mr. Ackerman, if we can just pause for a moment. We have reached the 45-minute mark, and the team in Cape Town have requested a short break. Can we?
I will proceed and deal with the Shikani matter. And
you wish to proceed?
Sure.
Okay. Well then we act under your advisement, and you just let us know when you wish to stop for a break. But before you proceed to the next document, this letter that National Commissioner Salebi sent to Advocate Pekoli, am I right in saying that he also sent it to the very same letter to Advocate Menzi Simelane, who was then Director General of the Department of Justice?
That's correct.
As well as Mr. Manzini, Director General, National Intelligence Agency. So it seems he was sending it to all of those individuals on the task team.
So the Simelane, the letter to Simelane is at page 91. Is that correct?
Sorry, Commissioner?
Page 91.
Yes. So those letters are from 91 through to 93, it seems, or 94 rather. Now, Mr. Ackerman let me draw your attention to the third paragraph of that letter, and I'll read it again to you. Commissioner Salebi says, I have insisted that the complainant be consulted in terms of the guidelines on the basis that the Directors General will have an opportunity to provide input, and here's the emphasis, before a decision on prosecution is taken. And then can I refer you to the next page, second paragraph. He says, although I do not insist on a meeting with the Director General after each meeting of our officials, I deem it necessary that the substantive reports and recommendations of the officials should be discussed by the Directors General before a decision is made. And then he ends off saying that in relation to the Chikani matter, that needs to be discussed both in terms of procedure followed and the way forward. What's your takeaway that Commissioner Salebi is insisting that the Directors General have an opportunity to provide their input before a decision is made on this prosecution?
It is unconstitutional.
And just to elaborate, the lay people in the audience, why is it unconstitutional?
Well, it's only the prosecutor, the National Director of Public Prosecutions, that are authorized to make decisions on court cases. And he has that sole discretion to do it. No outside agency can give an opinion on who or what charges a person must be prosecuted of. He is dominus litis on that matter.
So, am I right in saying that effectively Mr. Salebi is saying that until the NPA has heard from the Directors General, it can't proceed?
That's correct.
All right.
I
Thank
may
you.
add that on page 88, Advocate Piccoli then wrote to Commissioner Salebi, that's page 88, where he states that I advise that it is clear that our understanding of the mandate of the task team, as well as the guidelines that Cabinet approved, are not the same. In the circumstances, this matter, as well as other issues that have emerged in the course of the NPA dealing with the TRC cases, are currently being taken up with the Minister of Justice and Constitutional Development. That was his view on the matter.
All right. If you're happy to proceed, you can.
Now, I'm at this meeting, I just want to see when it was. In any event, Mr. Piccoli then instructed Advocate Ntunzi Maga to accompany me and to be witness what transpired. He was said that the meeting degenerated into a confrontation, I think he said. Now, at this meeting, Shikani stated that he is not against the prosecution, but he's not against the prosecution, but he's also not in favor of a prosecution. I cannot recall exactly how that meeting went. I'm quite certain that there must be a secret recording of the meeting, and I have no objection and indeed give my permission for the recording to be released. All I can remember that I asked him for his reasons for not being in favor of a prosecution, but I cannot exactly remember what reasons he advanced. I may add that this letter that I read last night, he gave the reasons why he didn't want to proceed, but I don't want to refer to that document at some later stage. I will.
Just on the score of Frank Chikani saying that he's not against the prosecution, but he's also not in favor of a prosecution. In terms of prosecutorial discretion under the prosecution policy and the NPA Act, if a complainant says, I don't want a prosecution, I'm not in favor of it, is the NPA or the prosecutor concerned obliged to follow that wish?
No. As a representative of the public, I will decide whether there will be prosecution or not, because in a serious matter like the poisoning of a high-ranking official, I'm not interested in the views of the complainant.
Is that because the NPA has to act in the interests of the wider society?
Of the public.
Yes. Thanks. Please proceed.
It's exactly because of that I already knew what his views were. That is Reverend Chikani. I might add, it's very important that the letter that I read last night of the National Director writing to the Minister about this meeting, you might, at some stage we will have to discuss it, but I didn't have the time last night to do it in detail, and I didn't want to get involved in that letter at this stage. But he said something like, he is now between the National Public Prosecutor and government on the different opinions, and he is in the middle. But I'm not going to refer to that letter anymore. The point that I would like to make is that it must be borne in mind that I was in possession of all this knowledge that the ANC feared that the prosecution of the perpetrators in the Chikani matter would open the door to the prosecution of the ANC leadership. And now, of course, Reverend Chikani was working for the president. I think he was his chief of staff. Now, with all that in the back of my mind, you must understand, I arrived there, I know he was going to tell me that he's not that interested in a prosecution. And the discussion I had with him at some stage, this is what I can recall. I told him, Reverend, you know, in any event, that's not that I really do need your evidence, but I can subpoena you in the terms of section, 179, that's to obtain the presence of any person at the court. I can remember also that I explained to him that if it does not be the correct version, that there are some other, he can be treated as a recalcitrant witness, and if he's really not happy with it, I'm not happy with his attitude, I can declare him hostile. I said that is in the act. And of course, I think that upset him because somewhere I read he said I was very hostile towards him. But I think that it is because I explained all the legal sections of the Criminal Procedure Act to him. In any event, in this other letter, Maga gives a full record of what happened at that meeting. I then proceeded with the prosecution. That was the end of the matter.
Mr. Ackerman, before we get to the court proceedings in that matter, should we take a short break at this point?
I appreciate that.
Okay. Can I just check, would 15 minutes be good, or would you like a longer break?
Yeah, 10 minutes, 15 minutes will be fine. I'm just lying down a bit.
Okay, 15 minutes if the Commission so permits.
We'll adjourn for 15 minutes.
As the Commission pleases. of count 1, accused number 1 and number 2. Each of the accused is sentenced as follows: 10 years imprisonment, wholly suspended for 5 years, on condition that the accused are not convicted of a crime in which assault or the administration of poison or other hazardous substances form an element, or of conspiracy to commit such a crime, committed during the period of suspension, and in respect of which a sentence of imprisonment without the option of a fine is imposed. And then in relation to accused number 3, 4, and 5, each accused is sentenced as follows: 5 years imprisonment, wholly suspended for 5 years, on condition that the accused are not convicted of a crime in which assault or the administration of poison or other hazardous substances form an element, or of conspiracy to commit such a crime, committed during the period of suspension, and in respect of which a sentence of imprisonment without the option of a fine is imposed. And we'll just let you know who the accused were. Accused 1 was Johannes Velder van der Merwe. He was the former Commissioner of the South African Police, also head of Security Branch. Adrian Johannes Vlok, former Minister of Law and Order. And then the rest were members, officers of the Security Branch: Christoffel Smith, Gert Jacobus Otto, and Hermanus Johannes van Staden.
Yes, thank you.
Thank you, Commissioner. Mr. Ackerman, before we proceed, one more follow-up question. So you mentioned that that case ought to have opened the door to the prosecution of General Basie Smit, who succeeded Johan van der Merwe as commander of the Security Branch in 1988, as well as other senior officers of both the South African Police and the former South African Defence Force. However, no further cases were pursued. Why were no further cases pursued?
Because there must be a number of reasons, but I think that they did not make any effort, they didn't disclose all the information. It was part of the sentence agreement that they will submit affidavits implicating Basie Smit and whoever. I never received those affidavits. I don't know why they were not obtained. So there was no case against Basie Smit.
Okay, let's...
And of course, we were interested to know where the poison came from. There was a list of people that they had in their possession. We wanted to know who compiled that list. Where did they get the poison? But that was the end of the matter after this conviction and sentence.
You can proceed, Mr. Ackerman. I think you were about to deal with the role of Mr. Chakani before the Ginwala Commission.
I only, as I stated, read the Ginwala Commission's report and not Chakani's verbatim evidence at the Commission. In essence, it appeared to me that the Reverend Chakani had two complaints. That is, the manner in which the plea and sentence agreement was conducted, and he is expected that the process should have as its purpose the revealing of the whole truth about the poisoning and how the state institutions were used. I'm in fully agreement with his views on the matter. I was not a party to the negotiations regarding the plea and sentence agreement. There was a separate committee formed, I think it was under Dr. Pretorius. There were 3 or 4. And they completed this. The result that they had was that sentence agreement is is the final say on the matter. I can state clearly that I also was against this committee, and I told Mr. Piccoli I didn't want to form part of this committee, and I did not form part of the committee, and I had no input on the committee. It was their decision. That's how it was produced at court.
Okay, unless you've got anything further to add in relation to the Frank Chikani matter, perhaps we can proceed to the evidence you'd like to give in relation to former acting NDPP, Nkosazana Mshe.
Now, about a week after the suspension of Mr. Piccoli, I received a telephone call from the acting NDPP, Mr. Mshe, and said I must come and see him in his office. He informed me that after due consideration, he decided to remove me from the TRC cases. He told Mr. Mshe, and I told Mr. Mshe that it was not he who took that decision to remove me, but that the minister instructed him to remove me from the cases. I then gave Mr. Mshe the background of the meetings that Mr. Piccoli had with the minister and Celebi the past 2 years pertaining to my involvement in TRC cases, and that they demanded that I be removed from the cases.
Just in terms of timing, this would be September of 2007.
Yeah, I was under the impression that it was in beginning of October. I'm not sure, but
yes, it could have been October because Mr. Piccoli was suspended. We'll get you the date, but it's during September 2007.
27th of September, he was suspended, and I say a week later. That's how I recall it, and that it was a week or 2 weeks later. My diaries, I requested my diaries. I asked phone Mthunzi Maga and said, get hold of my diaries. But of course, I'm quite certain I wrote something in my diary about this matter. I have not received it from my diaries from the NPA. My diaries concern, I had 2 diaries. The one was where I put my personal, if I say personal matters, it will be personal work matters. And the other one will be on operational matters that I refer to. So I'm looking for these 2 diaries so that I can give the correct date when he called me in. I made a note of it.
Thank you. Well, it's been then NDPP Piccoli was suspended on the 23rd of September 2007. So if it was 2 weeks later, then you're right, it probably would have been in early October.
As I said, I told him, I gave him the background, and then Mr. Mshe quite honestly looked at me and he says, no, it was not the minister that requested him to remove me, but that it was the Director General, Mr. Simelane of Justice. Must I have found it very ironic, but according to him, it was not the minister. I asked Mr. Mshe who was going to take over from me, and he said that he was still considering that aspect. My parting words to Mr. Mshe was that he must remember that the TRC cases are a given and that they are not going to disappear. That was now in 2007. I don't think anything happened after 2007. And Mr. Simelane submitted an affidavit to this commission.
Just before you go in there, interested to learn whether Mr. Mche gave you something in writing why you were removed from the TRC cases. Was it all oral, nothing in writing?
Nothing in writing. He just said after due consideration, he decided to remove me.
And the due consideration without content, just due consideration? Just that blunt statement?
That's correct, Commissioner. And that's why I told him then, that's not he who's taking that decision. I know it was the minister who gave him the instruction, and that was, I deduced from what happened a week before or 2 weeks beforehand. Mr. Piccoli was suspended, and so of course there were only two obstacles. It was Mr. Piccoli and I. So 2 weeks later, when he became I don't know when he became the NDPP, he called me in and said, after due consideration, he's taking me off.
Okay.
I didn't receive any written instruction, and to be honest, I don't expect that there will be a letter to the effect stating that you are now taking off TRC matters. He said it to me, and I accepted it.
Yes, thank you.
Before we proceed, Mr. Ackerman, and in relation to the Commissioner's inquiry about whether there was anything in writing, Commissioners, on Tuesday evening, the Secretary of the Commission did release some documents, and in fact, Mr. Ackerman is more on the ball than I am, because he spotted those documents. I had an opportunity to look at them during the tea break, and there is reference to the removal of Mr. Ackerman in a letter from acting NDPP Mche to the Minister, and I think this would be an appropriate time to hand up those two documents with the leave of the Commission.
Yes, you may do so.
Have a look.
And I am advised, we have asked the Commission to make copies available for the evidence leaders and the parties, and I'm told that those copies are on their way. So the first document is a letter dated 24 January 2008. And it's from Advocate MJ Mche, SC, acting NDPP, to Ms. B. Mabandla, MP, then Minister of Justice. And the title of the letter is Representations, Reverend Frank Chikani. And if I could draw your attention to page 2 at the top. And I will read into the record the first 3 paragraphs and then ask Mr. Ackerman for his response. Advocate Mche says, as a result of this letter and the prominent role played by Advocate Ackerman, I have deemed it prudent to relieve him from all his TRC-related duties since November 2007. As you are aware, Advocate Piccoli has been suspended and his future role is presently the subject of the Ginwala inquiry. I have decided that all future post-TRC investigations and prosecutions be managed by Dr. Ramaite, Advocate Maga, and the TRC task team. So, Mr. Ackerman, I assume you've had time to digest that letter, and in particular the paragraphs that I've mentioned. What is your response? What is your view in relation to what the acting NDP PM chair says.
Commissioners, this letter caused me not to sleep last night. As a result of this, what he says is, this letter, I don't know what letter he refers to. He says, as a result of this letter, it must be the letter that Reverend Frank Shakane wrote to the minister or to somebody. Out of the letter so I can see what this letter stated. But because of that letter, he deemed it prudent to relieve him from all TRC duties. It says since November 2007. My recollection is that it was shortly after, if I say shortly, 2 weeks after the
suspension of Mr. Pekoli.
Suspension of Mr. Pekoli. That's why my diaries are very important, because it will be reflected in my diaries when he relieved me. And it says, I decided that all future post-TRC investigations and prosecutions be managed by Dr. Ramehiti, Advocate Maga, and the TRC task force. Well, at least now we know who did not work on the TRC matters. It appears to me as Dr. Ramehiti and Advocate Maga. I don't think the TRC task team was still operating during the period October 2007 and to 2017. Dr. Ramehiti must be able to tell us, was he in charge of it, or was it Maga? Maga was one of my personnel. He sat on the staff complement of me. I gave him work. He never said to me that he is now working full-time on these post-TRC investigations. And Dr. Ramehiti also didn't tell me that he's now in charge. I must say that I thought the obvious person would be Chris McAdam, because he knew those cases. And when I spoke to Mr. Mshe, I think I indicated to him when I said it won't go away, and Chris has got lots of works, because I thought he was going to appoint Chris McAdam. I read in this document now that he appointed Dr. Ramehiti, Maga, and the TRC task team. That's my comment on it.
Thank you. Commissioner Como, that's the only document that we have, at least in relation to this particular incident. But if we find any more, we will certainly bring it to your attention.
Thank you very much.
Mr. Ackerman, before you proceed, and I think...
Just to confirm, when we receive the document, we'd appreciate it that
Yes.
photocopies are made for us. Thank you.
Yes, I believe the photocopies are on their way to you, Ms. Moroka.
And my team will correct me if I'm wrong, but I believe that they are also on the website. We'll just confirm that. Mr. Ackerman, while we're on this letter and on page 2, perhaps I'll read the middle paragraph and seek your comment. It says, Advocate Ackerman admits that he had some concerns about the guidelines and in a number of official memoranda raised his concerns on the constitutionality thereof. Despite reservations, he diligently applied the criteria as stipulated in the guidelines. With the wisdom of hindsight, it appears that there was some merit in Advocate Ackerman's reservations. Indicative thereof is the institution of a civil action in the High Court challenging the validity of the TRC guidelines. And then he quotes the citation of the Nkadimeng case. What's your response to that paragraph?
Well, I think it's a correct reflection of the facts in that I can recall at least wrote 2 opinions on the matter. I'm not sure to whom I gave it, but I'm quite certain that Gerrit Nel had insight to these opinions, because I had long number of discussions with him on these my reservations, and I told him straight that it is unconstitutional, and we had our discussions. But of course I applied it, even if it's an unjust law. I thought, for me, I also read the Prince to the end justify the means. The end I was interested in was justice. And if I had to use this task team and the policy, I must do it. So he's correct if he says that I diligently applied the criteria as stipulated in the guidelines.
And can I draw your attention to page 5? And at the bottom of page 5, there's a subheading called The List. And I'll just quickly read that paragraph into the record. I am informed by Advocate Ackerman that extensive attempts have been made to obtain knowledge of the contents of the list. He even went as far to use it as a bargaining tool, not to accept any plea agreement. All avenues to obtain the list have been explored. Matters of this nature would not form part of a plea agreement. Please advise the Commission what is the list being referred to here?
I didn't read this far last night, but the list he was referring to was the list that we had of all the people that, I don't know, should be poisoned. It was a poison list. And in terms of the amended TRC policies, is if you accept the plea, and that's what the President said in his statement, we must obtain information and there must be full disclosure of all the facts before we can accept a plea. In this matter, a plea was accepted and we got nothing in return. All we got was a 10 years suspended sentence, and that was the end of the matter. Now, I can't recall it, but it's obvious now when I read it that I did that in terms of this undertaking of them that they will make full disclosure, and they didn't.
So it does seem that list is a very important list, because as you say, it would have included individuals who were targeted for elimination, potentially by poisoning or some other means. Would you agree that it's important that efforts are made to obtain that list and to see who is on it, in order that the families affected can be advised?
Of course.
Is there anything else you want to raise in relation to this letter before we move on?
I stated this morning, when I found it, I started reading it, and I see I find certain paragraphs here.
Mr. Ackerman, can I suggest that we don't read the letter now? Perhaps you can read it later today, and if there's anything further you wish to add, you can bring it up tomorrow if you want. And then can we quickly deal with the other internal memorandum that that you wish to refer to? And Commissioners, this is the second document. It's also from Advocate MJ Mshare. It's from Advocate Chris McAdam, who was then Deputy Head of the PCLU, and it's addressed to Advocate Mshare, acting NDPP at that time, and it's dated 9 June of 2008. And Mr. Ackerman, this document focuses on the Pepco 3 case, and according to Advocate McAdam, it requires urgent attention. Now, the background is already before this commission. We don't have to go into that detail. We're aware that there was a review of the refusal to give certain of the accused amnesty. But let me read to you the second paragraph on page 2. To date, no date for the hearing has been fixed, although Advocate Ackerman, SC, and I were given the assurance that this would be either early or mid-2008. Obviously, the Judge President would not be able to convene a full bench to hear the review between now and 5 August 2008. It would be enormously damaging for the Pepco 3 matter to be struck from the roll due to a failure on the part of a State Department. And the rest deals with the postponement. What's your response to the statement by McAdam when he says it would be enormously damaging for that matter if it were to be struck from the roll due to a failure on the part of a State Department?
Chair, you will recall that when I gave my view on the Pepco matter about the review, I referred to the review that I also stated that Mr. McAdam will be able to tell us what happened, because I recall, just remember, I was now taken off TRC matters, but we're sitting in our office and McAdam will, during tea time, tell me there's problems that he had, and I will ask him about the review. And this was what I was referring to when I said he will be able to tell us exactly what happened. Because the back of my mind, I clearly remembered he told me, and now we must go and prepare a memorandum and find documents to assist Mr. Mshare to play a role in the review proceedings. I might be wrong on it, but that's my recollection of what happened about this. This letter was also came up to light only, what was it, last night, because that's when I read it. And it must be followed up with Mr. McAdam or Mr. Mshare, the roles they played. Because I know I stated that for 5 years nothing happened pertaining to this review. And now I see it was struck from the role due to a failure on the part of a State Department. That's a justice. I tell you, I was appearing at least 3 times in the court, and every time the judge will ask, has it been convened, this new amnesty hearing? And then I will say no, and I will contact the Department of Justice. There's a specific person, and asking whether they're working on the matter. But as I say, McAdam will be able to inform us exactly what he did. But I know he told me he prepared some documents in the Pepco matter.
Thank you, Mr. Ackerman. Let's now return to the evidence you wish to give, or the balance of the evidence you wish to give in relation to Mr. Mshare. And I think the last few words you mentioned were that his parting words to you was, or rather your parting words to him was that the TRC cases were not going to disappear or go away. Do you want to pick it up from there?
Yes, and at some stage, the last week or two, Mr. Simelane submitted an affidavit to this commission in paragraph 47. Of the affidavit, he stated the following: as far as I can recall, I never engaged with Advocate Moshe regarding the removal of Ackerman from post-TRC cases. There would have been no need because as far as the cluster was aware, the issues were resolved. Commissioner, there's something that I must now tell what happened. In my first affidavit in the Khampepe matter, that's 2015, when Mr. Barney came to me and he asked me they wanted a consultation with me, and I told him what the position is regarding the political interference. Chair, I know we talk about political interference. I think we can just simply say interference. And when he presented me with the draft affidavit, I informed Mr. Varney about Moshe informing me that it was the Director General who informed him. And I said to him, he must remove that from the affidavit. And just simply state, I don't know what I stated in that affidavit, but it was removed. And I, at good reasons, valid reasons why I decided that that must not appear in the draft affidavit. He presented me then with my affidavit that I signed. Perhaps I can just read what I stated in my affidavit. I haven't read it lately.
If you just hold a moment, we'll find it for you.
On paragraph 37, I state the following.
Just wait a moment. Before we read anything, we have to advise the commissioners what document we're reading from and where they can find it. So, commissioners, this will be bundle 3 of the Kalata Group bundles, and it's at page 16 of that bundle, and it's paragraph 37. You may proceed, Mr. Ackerman.
Allow us to be on the same page. Sorry, Mr. Advocate Ackerman.
Page 60. I don't know if that's relevant.
Page
Which
16
paragraph?
of the bundle. And at the bottom of the page, paragraph 37.
I state the following. Advocate Vusi Pekoli was suspended from his duties as NDPP in September 2007. Shortly after his suspension, I was summoned to the office of Advocate Mukateri Moshe, then acting NDPP. Advocate Moshe advised me that I was relieved of my duties in relation to the TRC cases with immediate effect. Then I say, I have no doubt that Advocate Moshe received a political instruction to remove me from these cases. I advised Advocate Moshe that removing me from the TRC cases would not make these cases go away. Of course, when I gave evidence here, I stated that Mr. Miche told me when I said it's a minister, he said no, it was Mr. Simelane who told him. Now, I asked the council to remove that, and I have my reasons, and I wishes to give you my reasons why I did that. Commissioners, in my life, I base all my decisions on probabilities. Every decision I make, I take the probabilities. And I anticipated a certain scenario. And the scenario that I anticipated is that there will be a civil court case in the Tembi Simelane matter, and that I will have to be a witness in that case. And my evidence will be to the effect that Mr. Miche told me that it was Mr. Simelane who told him to take me off the TRC matters. I then had to take a decision as to what are the probabilities that Mr. Simelane was going to admit that he informed Miche. On the probabilities, I decided that it was nil. I had previous information about Mr. Simelane. Commissioners, of course, that's my opinion. That's how I saw it at the time, making my decision. And I was not so certain about his. I read quite a few court case, and there was the Ginwala Commission, and there was also an interview I had with some newspaper, I think it was the Daily Mail. In the event, I made the decision that he was not. I anticipated he's not going to admit it. Rightly so, because I see he doesn't deny it. And I say rightly or wrongly, my opinion was then that he was going to be untruthful on that subject. Now, if Mr. Simelane denies that he told Mr. Miche to remove me, the next question is, what is Mr. Miche going to say? And if he also denies that Mr. Simelane told him to remove me, I had problems. Who is going to be the presiding officer, the judge? And he will have to make certain decision. He is going to make a credibility decision on two prominent persons in the legal fraternity of South Africa. That is the Director General of the Department of Justice and the head of the Prosecuting Services of South Africa. Now, against that, should he believe me, the word of a prosecutor of the older regime? I then made the decision that the odds are against me. It is a 2-to-1 decision. 2 will state that I'm not telling the truth. And it must be borne in mind that at that stage, I've been framed many a time. And I went through the mill in the Department of Justice. Many false claims have been lodged against me during that time in my career. So I made the decision just to say it can safely be assumed that he received instruction from political instruction. I can't even recall what exactly I said. Now, Commissioners, I also took out, of course, another insurance against the evidence of Mr. Mshe and
Similani.
Simelane. In my affidavit to Commission, I also deliberately left out a very important fact that Mr. Mshe told me. He said that the meeting between himself and Simelane to discuss my removal from TRC cases took place at an airport, and he stressed that it was not a formal meeting. Now, it would be very easy for the Commission investigators to establish from flight records whether Mr. Mshe and Mr. Simelane were together at an airport between the suspension of Mr. Pikoli and the date I was received from my duties.
Which airport was it?
He didn't state, and I didn't want to elaborate on that. He just said it was at an airport. How I can remember it so vividly is at the time, I thought by myself, in my experience, that is where underhand handovers and meetings take place, usually at the police, at the petrol depot on the highway, large petrol stations, or at airports. But of course, I didn't tell him that. But that's why I remembered it was at the airport. Now, I was right in that Mr. Simelane is denying that he told Mr. Mshe that, no, he said in his statement he never had any discussions with any person. I don't know. I was waiting for the statement of Mr. Mshe to hear what he is going to say about the matter. Whether he's going to deny that he told me it was Mr. Simelane.
Thank you, Mr. Ackerman.
Those are my reasons, and I expect to be cross-examined on it.
Mr. Ackerman, unless you've got anything further to add on the issue of the role of Mr. Mshe, can I suggest that we take a break?
I appreciate it.
Commissioners, Chairperson, the request from Cape Town is that this break be 20 minutes if the
20
Commission agrees.
minutes. We'll adjourn for 20 minutes.
As the Commission pleases.
Mr. Vani?
Chairperson, I think we're ready to resume. Mr. Ackerman, I think we'll just deal with one more part of your evidence today, the evidence that you wish to give in relation to the role of Advocate Menzi Simelane.
Yes.
If you're ready to proceed, you can.
Yeah. Commissioners, I'm of the view that the affidavit Mr. Simelane submitted to the Commission is one of the most damning pieces of evidence to prove the existence of a political interference. Mr. Pikoli and I were the only two obstacles that the Justice Cluster had to contend with pertaining to the decision of TRC Prosecutions. And the cluster had to find believable reasons to remove us from the TRC cases. I'm of the view that the reasons President Mbeki advanced for suspending Mr. Pikoli is unbelievable and far-fetched. President Mbeki stated that the reason for suspending Mr. Pikoli was to prevent a gunfight and a bloodbath in the middle of Pretoria between the DSO and the police to prevent the DSO from seizing documents.
Just before we move off that topic, so this, you say that President Mbeki wished to prevent, and I'm sure those words, gunfight and bloodbath. Are you quoting from a report or some document when you refer to those words?
No, that is paraphrasing what the President said in his affidavit, the reasons for the suspension of Mr. Pikoli. I found it in the affidavit that Mr. Mbeki submitted. I'm not sure whether it's in connection with the Nkabeng matter or the Ginwala Commission or for this commission.
Okay.
I opened the website and I read this. It is, I can even refer you to the paragraphs where I found it, and this is what I have. I can read his affidavit, the part that's relevant that I paraphrased. Can I read that into the record?
Yes. Is that the affidavit by President Mbeki before the Ginwala Commission?
You ask me, there's so many affidavits. I just open up and I read an affidavit on my tablet. I'm not sure where I don't read the whole document.
Okay. If it's just one paragraph, you may go for it. It's
from paragraph 70. It's
Yes.
a few
Sorry,
paragraphs.
Advocate Ackerman. Ms. Moroka has a point to raise.
That proves very difficult, Chair, if I may. Mr. Ackerman quotes an affidavit. He's not sure where he's sourcing it from. We're not sure if we were to go and look for that affidavit and read it for purposes of either elucidation or cross-examination. We won't be able to do that.
Yes, I am sure you will get an opportunity to cross-examine him on that.
But that's not the point, Chair. That's not the point. The point is, where is the document? How do we find it? How do we relate
Yes, I am sure Mr. Vani will be able to assist him in that regard.
Yes, perhaps we can just move on. I don't think it's a central point, but we undertake to locate exactly where that affidavit is in the record and bring it to the attention of the Commission and the parties. Mr. Ackerman, no need to read that passage. You may proceed with the balance of your evidence.
Now, I say that according to Mr. Simelani's affidavit before this commission, I had to be removed from the TRC cases because I was apparently a well-known apartheid prosecutor who prosecuted the comrades of the liberation period to paragraph 23 of his affidavit. Commissioners, it's false. It's blatantly untrue, and there exists no basis or evidence to make such a statement. Those were the reasons advanced by the Justice Cluster to remove me from TRC cases. It can be proved that the reasons advanced by the Justice Clusters were false. If it can be proved that the reasons advanced by the Justice Cluster were false, then automatically one should ask the question, why was it necessary to produce a falsehood? Why also advance a falsehood against Mr. Pikoli? In any event, I declined to prosecute President Mbeki and 37 others of the ANC leaders as early as 2003, and everybody was aware of that fact. There were press releases, I think it was May 2003 already. There are documentation. Minister Penny Maduna was informed. The two policemen, Brits and Nell, were informed. Wagner was informed. AfriForum was informed. They had to find some other reason, and that was that I was apartheid prosecutor. In paragraph 23 to 40 of Mr. Simelani's affidavit.
If we can just pause for a moment, Mr. Ackerman. Commissioners, the press releases dealing with the ANC 37 that Mr. Ackerman refers to, that's attached to McAdam's bundle, and in the in the bundle that we have provided, I believe that's at page, those clippings are at page 37, in relation to the interaction with Minister Maduna, that's reflected in bundle 1 at page 325. Thank you, Mr. Ackerman. You can proceed.
Now, in paragraphs 23 to 40 of Mr. Simelani's affidavit, I'm going to read where he makes certain statements. Now, as far as I can recall, I never attended a Justice Cluster meeting. I've never been to the west wing of the Union buildings. I've never accompanied Mr. Pikoli Justice Cluster meeting. I've never attended a meeting chaired by Commissioner Selebi. I've never met Commissioner Selebi. I never met the Secretary of Defense or the ministers mentioned in the Justice Cluster. I cannot recall making inputs at the cluster meeting. I cannot recall informing the Justice Cluster about people complaining about their treatment in exile, and I've never taken their statements. I never attended a meeting which descended into disorder. I cannot recall having a list of the members of the so-called military council or a list of the ANC leaders in Lusaka. Never attended any meeting where my removal from the PCLU was discussed. Simelani states in his affidavit that the official documents of the Justice Cluster in the form of agendas, minutes, and reports are available in the Department of Justice. These documents must be obtained so that we can ascertain whether I attended these meetings because I cannot recall it. We did ask for those minutes, and the Justice Department sent us, well, I don't know, it must be about 50 pages of meetings 50, that they had, but we couldn't find these minutes and the reports. I intend only to refer a few reliable sources and persons who can vouch for the principles I lived during by my time at the prosecuting office. I refer to
Mr. Ackerman, before we talk to people who can vouch for you, I think we need to deal in a little more detail with some of the aspects arising from Advocate Menzi Simelani's affidavit. So you've made reference to paragraphs 20 to 40. I think 23 to 40 at least. But we do need to go a bit further back. For example, paragraph 20. Commissioners, I assume that you have access to the affidavit of Menzi Simelani. Paragraph 20. I'm just going to read to you an extract, and you can respond. It reads, in preparation for the meeting, it was agreed that the police, defense, and intelligence services primarily, but anybody else, if they did have, would indicate their concerns to the rest of the team, which they did. It was at the presence of Advocate Anton Ackerman, SC, as the lead person on TRC cases, and the NPA was creating unhappiness in some quarters because of his alleged links to the persons it was alleged were likely to be investigated and prosecuted. It was suggested that Ackerman was an apartheid prosecutor, meaning that he was a prosecutor before the democratic dispensation and prosecuted comrades on behalf of the apartheid government. It was understood that the word comrades referred to members of the liberation movements who were prosecuted by the government of the apartheid-era. Your brief response to that?
No, it's false.
And then let's
I've
turn to...
never prosecuted any of the comrades. I can recall of one case, and that must have been in 1977, and the advocate for the defense was Pius Langa. He later became the Chief Justice. And when he saw the indictment, he said to me, his first time that he's seen an indictment where the accused are prosecuted for murder and not for the terrorism acts. It was a simple murder matter, but commissioners in those days, in the 77, in the 70s, 80s, probably in the 90s, indictment against the comrades, as he refers to, was about a 4 or 5 page preamble in how the accused conspired with the Russians and Lenin and MK. It was a preamble that was about a person's political beliefs. I never prosecuted in my life a person for his beliefs. I prosecute for the common law crimes of murder, and he was thankful to me that the indictment was so easy. That was the only case that I can think of that I prosecuted in. I was asked, I was requested by the minister who wants to fly up to Pretoria and be involved in the case against Mr. Busak. I've given you documents. What transpired in that case was exactly the same They also wanted a grand conspiracy trial, and I said the indictment is simple. It was, can't recall, economic protests that they had. Other than that, I don't know of any case. On the contrary, you will see how I was accused. You will read the evidence, the documents where I was, in fact, accused of making heroes of the UDF and the ANC. You will probably read that at some stage.
Yes, we'll get to that. We just need to deal with all the allegations by Advocate Menzi Simelane. Then in paragraph 21, he says, I was then tasked as co-chairperson to go ahead and indicate to Advocate Macaulay what the concern was, and that the view held by the police and the intelligence services is that it was not supported that Ackerman lead this process. Further, that because of his history, there was unhappiness, especially in the police and intelligence services, about the prospect of dealing with him for the reasons mentioned above. The view expressed at the meeting was that he should not be involved in TRC cases, and that Advocate Macaulay should remove him from these cases and consider appointing somebody else from the NPA. In paragraph 22, I requested to meet with Advocate Macaulay at the NPA offices, and in our meeting, I informed him of the meeting of the members of the cluster. I indicated to him what was discussed and the view widely held. I also informed him of the request for a full meeting with the DGs and other members of the cluster to discuss the matter. He agreed to the meeting, but not with the suggestion. I do not recall everything we spoke about, but he made it clear that he would not remove Ackerman from the head of the PCLU. And then finally, paragraph 23, a meeting was subsequently scheduled, and it took place in the West Wing in the Presidency. Although this was not the regular cluster meeting, including all the departments of the cluster, present were the members mentioned in paragraph 19 above, and others who I do not immediately recall. I remember these ones because they were most vocal about the concerns of their departments. From their contributions in the preparatory meeting, they indicated their concerns, informed in part by their and their members' personal experiences with the operatives of the apartheid government as commissars and commanders in exile, and also in part from a lot of comments and reports they were receiving from their members in their department and outside of government. Your brief response?
I did not attend any meeting in the West Wing.
And then lastly, I draw attention to paragraph 37. This is the last paragraph we'll deal with. The argument back and forth continued, and then Ackerman sought to provide additional clarity by stating that the PCLU cannot ignore the complaints that it had received, and that in prosecuting all the cases they will proceed with the one involving a former apartheid government individual. He didn't name the person concerned, and when done, then start with one on the other side. When asked to clarify, he indicated that the NPA had a list of the members of the Political Military Council. I do not recall the exact name. The highest decision-making structure of the ANC in Lusaka, Zambia, whose members were subject of the PCLU investigations because in that capacity they were accountable for the decisions that were taken by the commanders on the ground about which the complainants had complained. In that regard, the NPA viewed them as prosecutable. A list was produced and alleged to be of the members of the Political Military Council, and it was passed around for everyone to see. I do not recall if it was given back to him or what happened to it afterwards. It contained members of Cabinet at the time. Your response?
Chair, I cannot recall ever having such a list. I managed the prosecutions of the TRC matters, and I know of, I don't know where I read, perhaps in books or what, about this decision-making structure of the ANC in Lusaka. I don't know if Wagner told me about what is in his docket, but I would never have told any person that I have this list and I'm going to investigate them. I cannot recall anything about this.
Do you not
This
recall,
list must be
Mr. Advocate Ackerman, do you not recall or you didn't have such a list?
I do not recall having such a list, and that the list must be available somewhere if it was produced at this meeting. That's what I heard. Nobody gave me a list. I don't even know where this meeting was. I cannot recall.
I'm just trying to establish the meeting. So Mr. Similani at paragraph 23 talks about a meeting in the West Wing of the Presidency. It doesn't appear to give a date, so it's a bit vague. All right, I don't think we can take this matter forward right now. Mr. Ackerman, you were about to talk about individuals who had vouched for you, and perhaps let's begin with a letter dealing with you that was prepared by the late George Bezos, SC. Commissioners, this is in bundle 3 of the Colata Group bundles at page 30, and it is dated 14 January 1988. To whom it may concern. Mr. Ackerman, would you like to read that into the record?
Yes. It says, to whom it may concern, dated 14th January 1998. During 1976 to 1977, I appeared at a formal inquest in the Magistrates Court, Johannesburg, on behalf of the family of Jabu Vilakazi, who was killed by members of the South African police. Prosecutor who led the evidence was Mr. A.R. Ackerman, now Senior Counsel in the Office of the Attorney General in Pretoria. It was contended by us on behalf of the family that members of the Brixton murder and the robbery arrested the late Vilakazi, took him for a so-called pointing out and then shot him in cold blood, and that their story that they did so because he tried to escape was a fabrication. It was customary during the period for prosecutors to defend the police irrespective of the weight of the evidence against them. To our surprise, Mr. Ackerman objectivity was demonstrated by submitting that the members of the Brixton murder and robbery unit were criminally responsible for the death of the deceased. In my view, this was a breath of fresh air and gave one hope that despite the pressures that must have existed on a comparatively junior member of the profession, he courageously and correctly submitted what he believed to be in accordance with his oath of office. We were not alone in that belief. The magistrate made a positive finding in accordance with Mr. Ackerman's and our submissions. I've always singled him out as an outstanding exception amongst those who thought that protecting the police was more important than serving justice. Although we have lost touch, I am reliably informed that he has continued to behave in an objective and proper manner throughout his professional career. I'm pleased to place on record what has been in my mind so long. just of interest in how what happened in the old regime. I was transferred, I think I argued this in, say, January, February 1977. That was after this inquest was held. The next month I was transferred to Maritzburg. I already put the offer in the house there. I was going to stay in Johannesburg, and they transferred me forthwith. Later on, yeah, that's all I want to say. I didn't ask for a transfer.
Thank you, Mr. Ackerman.
The letter is dated the 14th of January 1998
That's
by
correct.
George Bezos.
That's
correct, Commissioner. Mr. Ackerman, before we proceed and before I forget, my junior has just passed me a note to say that in the Menzi Simelane affidavit, he states at paragraph 17 that he doesn't remember dates, and that probably explains why there's no date to that meeting. Let's now turn to other individuals and entities that have vouched for you. Commissioners, we're now going to turn to an article that was published by Independent Online some 24 years ago. That's looking for a date. I don't see it. My colleagues will bring the date to my attention when they find it. But the article is attached to bundle 3. It's at pages 41 to 42. And it's followed by a write-up on Mr. Ackerman by one Rita Meintjes, and those are pages 43 to 46. Now, Mr. Ackerman, the heading of this IOL article, which was published some 24 years ago, is titled "Basson Prosecutor Gets International Honor." Can you explain to the Commission what honor this was?
Chair, that must have been before the judgment of the Basson case when this was stated. I went to Australia and got an award there from the International, I don't even recall who they were, Prosecutors Association. I can recall that the prosecutors, I shared this award with the Scottish prosecutors involved in the Lockerbie trial. The document speaks for itself. I haven't read this report, so I don't know who wrote it. Well, do you want me to state something from it? Or do you want me to read portions?
Let's.
Mr. Vani?
Yes.
We do not have a copy of that article.
My apologies, Commissioners. I was told that it had been added to Bundle 3.
No, it hasn't.
Do we have copies of it? They were handed to the Secretary of the Commission yesterday, and we had assumed that they would then be added to Bundle 3.
I don't have.
Do you have copies? I'm told that we have copies. Perhaps we can just hand them up right now.
Okay, thank you. Ms. Moroka, do you have?
No, Chair, I don't believe so.
Well, we don't want to leave Ms. Morocco out.
I'm quite indebted to my learned friend.
So the, the page number of the article, Commissioners, at the top on the right, it's numbered 41. And it will be added to bundle 3, that's Mr. Ackerman's
Yes, you
bundle.
will give the necessary copies to the other parties.
We just handed over copies now.
Thank you.
Chair, not a this one is spare.
Chair, I've now read this article. I think the only part that is relevant is perhaps the last 3 paragraphs, where it says, I see they asked me, what will it mean for my career? Ackerman smiling answered, a trip to Sydney. I, of course, can't recall this interview. I don't know who wrote this article. But in any event, I think the relevant part is Ackerman has prosecuted in some of the most publicized cases in South Africa's history. This includes the trial of Andre Stander, one of the country's most notorious bank robbers and a former policeman. Stander was sentenced to 75 years in jail on 23 charges of armed robbery. Other cases included the trial of Jermaine Phillips and Peter Grindlin, South Africa's Bonnie and Clyde, on 5 charges of robbery and murder. The trial of the Afrikaner Weerstandsbeweging leader Eugene ter Blanche on counts of public violence. The murder trial of Ferry Barnard and Eugene de Kock Marathon murder, fraud, theft, and illegal possessions of arms trial. Commissioner, I think there are very few people alive that still know the Andre Stander matter and the Bonnie and Clyde Phillips and Grindler matter.
Thanks, Mr. Ackerman. I'm told that the date of that article is 10th of June 2001.
Phew.
Now, we've also attached from page 43 of your bundle the motivation prepared by someone by the name of Rita Mainkies. At the bottom of the page, on page 46, she's described as a member of the executive committee. Do you remember who Rita Mainkies was or is?
Yes, she served on the executive of this international prosecution society.
And can you just read into the record paragraphs 2 and 3?
Mr. Ackerman is a man of unfeigned integrity and a prosecutor at heart. He proved himself to be a fearless litigator with a strong sense of fairness, who will pursue the case of justice irrespective of the circumstances or the consequences. Although Mr. Ackerman was a member of the apartheid legal state, he always remained true to his oath of office. His perseverance, integrity, and pursuit of justice was as evident in his prosecutions of terrorists who have committed crimes of murder and terrorist acts under the apartheid regime as it is in prosecutions of high-profile employees of the apartheid government who committed crimes. With all due respect, I don't know to who she refers when she talks about this terrorists who committed crimes of murder and stated there.
All right, and then she refers to various cases, some of which you've already alluded to, such as Mr. Busak. There's also a reference in paragraph 6 to the fact that you were the...
May I read this paragraph 5? I haven't read this document for a long time. I found it amongst a file in my office, at my study. It says that in the 80s, Mr. Ackerman was instructed to manage another high-profile prosecution on behalf of the apartheid government, Mr. Alan Busak, a well-known anti-apartheid activist for the Contravention of Terrorism Act. After he drafted an indictment, it became apparent that the government wanted to make a political point through the prosecution. They insisted that the prosecution proceed on the basis of a grand conspiracy which would include all the prominent apartheid movements, including the internal United Democratic Front. Mr. Ackerman refused. His decision was based on sound legal principles. In a series of meetings with the highest political figures in South Africa at the time, including State President P.W. Botha, he maintained his point of view. Another prosecutor was then identified to prosecute this matter. A year later, the investigation into this conspiracy trial was abandoned. I can recall that matter.
And in paragraph 6, you played a leading role in the commission that looked into the conduct of a member of the House of Delegates, Minister Raj Bansi. Do you want to read into the record that paragraph?
During 1988, Mr. Ackerman was appointed to appear on behalf of the state in the high-profile Commission of Inquiry headed by Judge President James into alleged corruption by a member of Parliament, Minister Ras Bansi, who also chaired the Ministers' Council in the House of Delegates. During his 10-day-long cross-examination of Ras Bansi, the latter was exposed. The prosecution ensued as a result of the commission leading Minister Ras Bansi's conviction on a charge of corruption. I know a letter was handed to me by the Judge President James during this inquiry, and I've given it to you, what was said in that letter. Perhaps if I haven't got it here with me.
Let's skip to paragraph 8, please, if you could read that into the record.
Paragraph 8.
8.
Mr. Ackerman has prosecuted in some of the most famous cases in South Africa's criminal history. Andre Stander, South Africa's most famous bank robber and a senior officer in the police service, on 23 charges of armed robbery. He was sentenced to 75 years imprisonment. Charmaine Philip Quinlan, South Africa's Bonnie and Clyde, a runaway couple, on 5 charges of robbery and murder. Eugene Terblanche, the charismatic leader of the Afrikaner Weerstandsbeweging, a right-wing political movement, on counts of public violence in the so-called Battle of Ventersdorp. Perry Barnard, Eugene de Kock, and Wouter Basson.
And maybe let's conclude with the last paragraph. That's paragraph 15.
Thus far, Anton Ackerman has been the only prosecutor to prosecute former leaders involved in atrocities committed during the apartheid regime. He has clearly demonstrated special dedication in the pursuit of his professional responsibilities, even during the apartheid years, and has also discharged same in the face of hardship and adversity in circumstances which deserve recognition by an organization as the IAP.
The International Association of Prosecutors. So just to wrap up then, Mr. Ackerman, your response to the claim by Advocate Menzi Simelane that you were an apartheid prosecutor, a man not to be trusted?
It's false. Not correct.
Chairperson, I've been advised that the reference in Mr. Ackerman's evidence to President Mbeki saying that he wanted to prevent a bloodbath between the NPA and the SAPS, that's apparently a reference to a paragraph in President Mbeki's affidavit in which he sought to intervene in the application brought by the Kalata Group in the High Court last year. We will extract the affidavit and the paragraph in question and put it up to the Commission and the parties in due course. Mr. Ackerman, unless there's anything further to add in relation to people who have vouched for you over the years, I think we can wrap up for today.
I'm quite certain that Justice Azir Kachalia will vouch for me. And there's a letter, pages, I say 4 to 6 of 29th December 1988, a letter to President P.W. Botha from Rasbanshi that is, I am of the view, very important to state my views, what I did, and what Rasbanshi said about me. May I be permitted to read out of this letter? It can be handed in as an exhibit. It is addressed to President P.W. Botha, dear President, and it is signed by Mr. Rasbanshi.
Mr. Ackerman, we're just scrambling to find that letter. I'm told that it is part of the bundle. Oh yes, I see it. Are you referring to the letter dated 29 December 1998 from Mr. Rajbansi to President P.W. Botha? Commissioners, that's at pages 31 to 40 of the small bundle just handed up. I'm just looking at that letter, Mr. Ackerman. I see it's quite a long letter. Is your proposal to read?
I've marked here places that I think is relevant. Most of it was a long commission, and can I read out what Mr. Rasbansi stated in this letter? I will refer you to the page numbers.
Okay, if it's just a few extracts, please go ahead.
Page 4 on the top.
Which is page?
4.
It'll be paginated page 34.
It says there on the top of the page 34 then.
You may proceed.
Advocate Anton Ackerman used his powers to seize confidential documents from the administration and handed them over to ANC activists, Boga and Company, to be used against the administration with the knowledge of Justice James. Next paragraph. Advocate Anton Ackerman made heroes of another ANC activist, the Salaji family of Lenasia, by book orders. I had reminded Mr. Justice James in this chamber that ministers and certain officials had to task decisions in the interest of, in the security of the state. In spite of this, it was allowed the humiliation to continue. In the middle, there's no number, but starting with both, Justice James and Anton Ackerman championed the cause of the Chief Executive Director of Education and Culture, Mr. A.K. Singh, who in my opinion is a leftist and will steer the education administration, in my opinion, to the left-wing forces.
Towards the left-wing forces.
Towards, I can read there. And then on page 35, in the middle, towards the bottom, it says, Mr. President, Even like this, events like this did not happen before in our administration. These are the people whose cause was championed by Advocate Anton Ackerman and which was allowed by Mr. James. I'm afraid our Department of Education is moving to the left. Here, on page 36, which is the second paragraph on page 36. I believe that the role of Advocate Anton Ackerman succeeding the UDF has scored its greatest triumph, and history will record this. Those are the
Thanks.
to.
Thank you for highlighting those passages and the letter that Mr. Rajbansi addressed to P.W. Botha at that time. Is there anything further you wish to add or comment on?
No, there's nothing.
Thank you, Mr. Ackerman. That concludes your testimony for today. Commissioners, my attorneys advised me that reference in President Becky's intervening affidavit, that the term the bloodbath actually doesn't appear there, and that was Mr. Ackerman's paraphrasing of what President Mbeki said in that affidavit, but we will in due course put it up so that it can be inspected.
Yes.
Yeah.
Thank you. Is that all for Mr. Advocate Ackerman for the day?
For the day. There are a few more aspects we wish to canvass with him in the morning, Chairperson.
Yes. Do you think you'll conclude his evidence tomorrow?
We aim to conclude his evidence tomorrow.
Yes. The proceedings are adjourned until tomorrow morning at 9 o'clock.
As the Commission pleases.